Greetings, guys.
Hey.
How are you? Thank you for joining us for another No Sleep in the City, a podcast about all things family law,
That's right.
as well as asset protection and estate planning. My name is Genghis Shakhan. I am your attorney co-host, joined by the lovely Chelsea Wilkerson,
Hey there.
who hails from the great state of Georgia.
That's right.
I, of course, am from the Buckeye State. And, of course, I'm
Northman.
always representing the Ohio State University. I have on my scarlet. It is not gray. It is scarlet. No, actually, I don't have the scarlet on. I have my gray on. I'm missing my scarlet. I apologize. Scarlet and gray.
It's not. Let me not disrespect. I don't want to cause a scene.
Yes,
while
please,
don't. Let me not do that.
Don't disrespect the Buckeye State, okay? All right, guys. So what we're going to talk about today, we have a great topic for you. Today's topic is about why some clients win their cases while other clients might lose their cases, right?
Yes.
And so we're going to talk a little bit about the mindset behind the outcome. So this is going to be a great one,
factor.
Especially if you have a case that's pending in court or you are thinking about filing a case. This might be something that you want to tune into.
Real-time assistance.
Yes. So thank you for joining us today. Let's go ahead and dive right in, shall we? So winning your case isn't generally about luck, especially if you do the wise thing and hire counsel. It's preparation, behavior, and belief. And we'll kind of parse that out for you so you know a little bit more about what we're talking about. So we're going to talk a little bit about today's topic a bit more. Before we do that, let's talk a little bit about what you should get from today's podcast. We're big on this being a didactic experience for all of our listeners. All right, so you should learn today why preparation is better than passion, okay? So one of the things that we pride ourselves on at our law firm is our preparation before going into court, as well as preparation of our legal team. So we have a great team that can assist in hopefully getting us the win. And we'll talk a little bit about what it means to win in family law, right? Because there's different metrics in family law. It's not like personal injury.
Right.
It's not like, maybe some other areas of law.
Business.
Right. So winning means something different in family law.
Correct. Absolutely.
The top mistakes that may sabotage a case. That's always going to be a fun topic. And traits of a client who earned the court's trust. It's very important that, the judge, the jury trusts you and trusts your testimony. And we'll talk about, if we, have the time, some of the dangers of, being an unreliable witness in your own case.
Correct.
And then we'll also discuss what we wish every client knew before day one. So let's go ahead and dive right in. And let me ask this question to you, Attorney Wilkerson. So we have two clients, same judge, similar facts. However, they get different outcomes. Why?
Why? Well, great question, Attorney Shakhan. And again, I welcome you to the great state of Georgia. This is the best place to be. I had to tease you.
I don't disagree with
you. But two cases where there are two clients, similar facts, same judge, different outcomes. A lot of that has to do with what you covered in the opening, which is your conduct during the court proceedings. Also, what it can impact that is the level of preparation. We always prepare prior to a hearing, reviewing evidence, going over strategy, the topics that we're going to touch on when we're going into a client's case. However, sometimes clients will hide the ball. They won't share everything that is not only good, but bad or ugly about their case, not just about the other side, but about themselves. Do not surprise your attorney if you have representation. Let them know in advance if there's something hinky going on with your background or with you, as opposed to them being surprised in court, because that makes it difficult to be able to rebut certain allegations. Another one is making sure you turn over all the evidence that you have against the other side. Don't hold it back thinking it doesn't have value or you don't want to go that route. Let your attorney review it and discuss it with you and determine its value, whether or not it should be used. And then you guys can talk about if you guys don't want to go in a certain, quote unquote direction. But you mentioned a number of things, but how you prepare for court, how you show up in court, but also how you present yourself in court as well. When you're going to court, you want to make sure you're dressed the part. When you're going to court, you want to make sure you're on time. We talked about that in another episode, how that negatively impacted someone else's case. You want to make sure that you are presenting yourself in a respectful manner to the court. Don't speak over the judge. Let your attorney, set you up with questions when they're asking you questions. Don't try to bicker or say, oh, didn't you want to mention this? We know what we're doing. We are professionals. Trust your advocate to, point you in the right direction when it comes to their questions, as well as I said before, making sure to provide all evidence that you can and being honest when testifying. I know that may seem counterintuitive when you're looking at two attorneys, but we do tell our clients to be honest when they are testifying, because if you are caught in a lie and your character takes a hit, it is very, very difficult to rehabilitate your character in court once it has taken a hit. Even if it can be something like one or two little lies, those things add up. And on certain issues where there may not be direct evidence and the judge has to weigh whose testimony has more merit than the other, your testimony isn't going to carry that much weight because you've already been proved to being dishonest with the court. And the other side, even if they did the things you're accusing them of, has not shown themselves to be dishonest with the court. So that's a number of, issues.
Yes, I mean, when listening to you talk, it just reminds me, we field calls sometimes from folks who have, for example, hey, my buddy went through a divorce.
Yeah.
My buddy appeared in front of the same judge. Our facts are very, very similar. I'm expecting the same outcome that my buddy got, right?
I just need you guys to get it.
Right. And so what sometimes, to the lay person, they don't understand that, that there might be in one case a different set of financial facts.
Correct.
There might be a different financial reality between you and your buddy.
Correct.
Your buddy may be exercising more, if there are children involved, more parenting time.
Correct.
And might be entitled to more deviations regarding child support than you are entitled to.
Correct.
Right? Because of your, financial status.
Right.
There might be infidelity in one case. Your buddy may or may not tell you that, hey, I committed these acts of infidelity. Or in your case, maybe, your wife committed, if it's a gentleman,
yes,
your wife committed, even if it's a same-sex marriage, that, the opposing party committed an act of infidelity. And sometimes those things are bars to alimony,
correct,
right? Bars to spousal support, right? So facts can, on the surface, be very, very similar.
Right.
However, there might be, some very key and important differences in these types of cases. Have you had that experience?
Absolutely. Parties have been, say in the nuclear family setting, husband and wife to have been married for about the same period of time, have about the same number of children, about the same income, and in both in a two-income household. But in one instance, there was no real legal bad conduct that gave a grounds for divorce. They filed under 13th cause, which is irreconcilable differences, as opposed to the one of the 12 that are at-fault grounds for divorce. In another case, with the similar facts, it was an at-fault grounds for divorce. So one of the things you mentioned. In another case, one of the spouses committed adultery. They may have smacked their little spouse a little bit. That's not condoned, not making light, but just saying, they may have, done some little smacky in the house. All right. They may have been in and out of the house. So maybe not long enough to meet the legal requirement to be considered abandonment, but they were not consistently contributing to the house because they were in and out, maybe contributing to those other relationships in some other households. So while on the surface, the facts appear to be very similar and you're in the same county with the same judge, because you have certain factors that are unique in your case as opposed to the other case, then it can hugely impact your outcome. Also, what can impact it is how well the parties are behaving in court or behaving with one another. So your facts can start out being exactly the same as someone else's, but in a case that was mentioned on previous podcast, where one spouse has, started stalking the other one because they're obsessed with the person they're now involved with and they weren't involved with anyone before. Or in an instance where they have gone to the home of someone they're in a new relationship with and they got charges pressed against them. different factors, even while your case is going on, can make your case go in a completely different direction than someone else's cases. And we have dealt with that a number of times, having our clients have TPOs filed against them and granted, and they didn't tell us until the order was signed. We hired for their divorce case, and now we find out that they have criminal charges pending in one county and a TPO was granted in another. I still don't know how that happened. I would have liked to have known, but again, that's a conversation for another day.
Right. It's always fun when, a client doesn't disclose all the fact pattern to you and
Correct.
everything that's actually going on in their case.
Right. My case is simple.
Right. It's even more fun when you're in court and it's happening in real time.
Yes.
That's awesome.
Right. On the stand?
Yes.
I never heard any of this before.
Right.
Me and the judge are learning together.
Right. It's a learning experience for all.
Everyone.
All right. So one of the things that was mentioned is, of course, we said 2 clients, similar fact pattern.
Yes.
Same judge. And so there's the human factor that we haven't really discussed.
Yes.
Judges haven't been replaced by AI just yet. It might be coming,
Dear
lawyers,
God.
judges. Maybe one day you'll walk into, a
Starbucks.
courtroom and it'll be like the Matrix, right? Neo will represent you,
Right.
and Agent Smith will
With the
be
glasses.
prosecutor, right? And the
Thinking of
architect
coffee.
will be the judge, right?
Right.
Who knows what happens? But as of now, judges are human beings,
Correct.
right?
Absolutely.
And so a judge, can have a great day, have a full calendar, the next time you see them, and may not be feeling as hot, right?
Right.
Another thing, that sometimes clients need to consider is their likability. And it's very challenging sometimes to have this conversation with clients,
Right.
because you can come off as unlikable. I'm gonna put that a
Yes.
kind way
Right.
to a judge.
Right.
As counsel, as attorneys, what we attempt to do in many of our cases is we try to shrink, okay? We shrink
Right.
ourselves and we make the law big. We make,
Yes.
the statutes big,
That was
the
great.
case law big, right?
There you go.
You want to basically, you want the client to prevail. And so we try not to insert ourselves
Center ourselves out.
unless, of course, is, requires just zealous advocacy,
Correct.
right? We see that the level field, the playing is not level, playing field is not level.
Yes.
And, we have to kind of crash out, in a legal positive sense, right?
Right.
To make certain that our clients, case is heard, right?
Right.
And that, we stand up for them.
Right.
But-
Advocate strongly is what we'll say.
strong and zealous advocacy.
There we go.
Right. However, if a client is not believable, right? And you talked a little bit about rehabilitating a client's character.
Yes.
So if you have been caught in lies, and this is one of the things conversations that we have with clients, if you've been caught in a lie, no matter if it's a big lie or a white lie,
Right.
it makes it challenging
Yes.
when you give your testimony, especially if you're alleging that the opposing party is, committing parental alienation or,
Right.
some kind of, other
Stealing
egregious
money,
acts, right?
hacking
Stealing
into your
money,
accounts.
right? Some kind of marital tort.
Right.
It just your word is very difficult for a judge to believe,
Right.
right? Or a jury to believe.
Right.
And so that can impact your case. You can have the very same facts
Right.
as
On
the
the
case
surface.
law that we've researched. The facts can align perfectly.
Right.
However, the judge doesn't like you. Okay. And so, and what we try to do is coach our clients up, of course,
Yes.
on how to present well,
Yes.
if you will. And it also requires the client, because this is what you hired your attorney to do, guys,
Right.
is to read the room, right?
Yes.
Your attorney should be looking at the judge,
Yes.
looking at the jury,
Yes.
and saying, okay, listen, what we just talked about doesn't seem to be sitting well
Right.
with our audience. Let's
Right.
shift gears,
Right.
okay? But many times our clients are sometimes focused or emotionally,
Yes.
they're really just
Trying to jump in, and they do too much, thinking that they're helping their case.
Yes.
And that's often what people do as human beings, is that they're afraid, they're nervous, or they're frustrated. So they do more, and it ends up hurting their case more when they may just need to do less or listen to their counsel.
Yeah.
And to the points you were making, some people don't present well in court. They even just being dishonest with the court. Some people don't present well because they're nervous. Some people don't present well because they're angry that they're there. They weren't antagonistic with their partner at the time they separated, but getting into court, they're throwing everything in the kitchen sink at them, trying to get what they want, playing dirty, playing nasty, throwing mud. And they're very, very frustrated because the other party might bring the children into it. They might be bringing extended family and friends into it, bad-mouthing them outside the court, beyond where we can assist them, beyond where a judge can really assist them. And so they come into the court with a certain demeanor, and it shows in their testimony, it shows in how they are moving in the courtroom, because like it or not, more often than you realize, judges will remember you. And they very often remember people who make a bad impression. And they make a mental note, if not a written note, in their notes, because judges often take notes while you're testifying about your demeanor, about things that you have said, about things that you were truthful about, things that you were not and found out to not be truthful. And so, especially when you're saying with being dishonest, whether it's something big or small, judges will tell you, listen, I don't believe a word that's coming out of your mouth. They will tell you, maybe what you're saying is true, maybe it's not, but you've lied to me before. What's to say you're not lying to me now? Judges can be very direct and disrespectful in court, and they can be because they're the guy or gal in the black robe with the gavel that's making the decisions about your case. And so it is important to listen to the guidance of your counsel. Sometimes you do need to, there is a thing of court decorum and how you conduct yourself in court. You're not, again, being fake. You're not being disingenuous. You are just making sure to move in a way that it is in your best interest and present yourself in the best light possible.
Yes. And you mentioned just conduct, and I do want to touch on that.
Mm-hmm.
I've worked in cases where, my client has contacted the clerk and cussed the clerk out, has contacted the judge's assistant and fussed the judge's assistant out.
Yes.
And then, we find ourselves in court,
Right.
and maybe they've, looked at the bailiff sideways. A lot of times how you treat the judge's staff
Yes.
or how you treat folks in the courtroom
Yes.
can get back to the judge. It adversely impacts your case, folks.
Correct.
And so, again, it's a bad investment because you have spent tens of thousands of dollars
Right.
on this counsel and you're not taking the advice of counsel.
Right.
And the courtroom is not the place to be vindicated.
It's not.
We've had these conversations with our clients. You
Right.
are not going to get closure in the courtroom.
No,
The
unfortunately.
judge is going to rule on the legal issues. That's
Correct.
it.
Right.
Right? So there's nothing that's going to happen. You will have to see a therapist or a spiritual advisor
Yes.
on your own dime.
Yes.
If you want closure,
Yes.
right?
They're not going to call your partner a piece of crap in open court and make you feel better. And
Correct.
validate you.
You're not going to be healed as a result of this experience. If
Not at
anything,
all.
it's probably going to emotionally break you.
That's
Okay.
a break. Little harm, some little dings. Okay, it can break it sometimes, but it doesn't always.
It's an
It can be
ordeal,
grueling.
right?
It can be
They
grueling.
mentioned, for example, divorce in terms of life events is
That's
right up there
true.
with bankruptcy and death.
That's very true.
Right? So this is a very
Yeah.
arduous process. And you're going to, you're going to
Right.
walk through purgatory and
Yes.
probably get to the seventh ring of hell before you get to turn back around and,
Right.
kind of piece your life back together. So
Right.
it's very important if you've hired counsel to listen to counsel.
Yes.
But again, how you treat the court staff is super important. Your
Mhm.
communication style with the judge, right? Or even answering questions from the opposing counsel.
Yes.
You may not like the opposing counsel, however, and they might, try to ensnare you in these tricky questions and
Right.
make you look bad.
Right.
But, you have to portray and convey a sense of control
Yes.
and a sense that you have, you have it all together,
Correct.
right? So you can't be, up there and be sarcastic, be nasty, be
Right.
short,
Right.
belligerent, because the judge is watching you.
Right.
And so you can't see it, but oftentimes your counsel who is standing away as you are testifying, as witnesses are testifying, if you follow your counsel's eyes, at least I know myself and Chelsea do this,
Correct.
we are looking at the judge.
Mm.
We're looking at the jury. We're seeing what works and what doesn't work for you in
Yes.
real time. We are advocating for you. We want to prevail.
Yes.
Right? And so, we're only going to give you advice to help you prevail.
Right.
All right. So that's something that you want to keep in mind is your communication styles. And we're getting close to wrapping this up, so I'm gonna hit up on a couple more points. You're not going to win a lot of battles with your emotions. It's going to be with documents, with evidence, right? That's evidence is king, guys.
Yes.
So coming to court and testifying about how your spouse made you feel, how they were a narcissist, and how, essentially they antagonized you over the course of your marriage.
Right.
That sounds good. Show us some evidence, right? Show us some text messages.
Right.
Show us some videos, right?
Yes.
There have been physical altercations. Show us some police reports.
Right.
Show us some, if there's
documents.
been, some documents of showing where someone has, really decimated the marital estate.
Exactly.
Right.
You needed help with medical bills and they decided to, buy a new boat.
Right. That they're a spendthrift, that they are financially irresponsible.
Right.
Show us documents that they're a poor parent. DFACS has gotten involved, been called on them because of certain kind of allegations.
Correct.
Those are going to be the things that win the day. Yes. Not you, getting on the stand, espousing everything that's negative about the opposing party and crying crocodile tears, right? So make certain documentation is muy important, very important. And then lastly, delays and drama rarely work in your favor, right?
Correct.
So you want to remain drama-free when it comes to the courtroom. Okay?
Yes.
And listen, you can't overstate this enough, guys. Listen to your counsel.
Right.
All right, guys. Well, thank you for joining us for this podcast. As always, it has been a pleasure to share time with you. My name is Genghis Shakhan, and I'm here with my partner, Chelsea Wilkerson of Shakhan and Wilkerson Law.
Yes.
We look forward to chatting with you again and seeing you on the next podcast. Don't forget, however, if you are interested in our books, they can be purchased on Amazon as well as through Barnes & Noble. You can go to our the link in our bio. They are available on ebook and the ebook format, as well as you'll find that they're available in hardcover and paperback as well.
Yes.
There's also a free download, and so check that out. We look forward to seeing you on the next podcast. Yes. Remember to like, share, and follow. See you next time.
Later.